Well, we're 5 minutes after 11 o'clock, and I don't know that we're going to be joined by anybody else. I don't know. I mean, since this was a 5-member subcommittee established on law enforcement, we have to have a quorum to do anything, or no, not really. Well, as I said, told you a little while ago, Sheriff Russell told me he's not going to be here. He's going to be at a training, and yesterday Chief Cawthorn told me the same thing. I think he's at the same training, but they both reviewed the changes, or at least the suggestions I made in the document I sent out, and they said they didn't have any problem. They didn't see anything be an issue. Again, some of these changes I just put in there as a suggestion and just throwing it out there to see what people thought. I haven't heard from Mr. Walsh. Have you had a chance to review it?
I have. I actually looked at it.
I would ask if you could hit the microphone, because I am recording this in case. Sorry.
Mayor, can you hear me now?
Yes.
I had an opportunity to look at it, and I concur with the changes. Some of the of course, a lot of the things are quite antiquated. I know that that even in my tenure, though, as county attorney, one of the things that we have availed ourselves is the anti-noise regulations. Obviously, you don't see a whole lot of that charges under a citation or at a warrant in your sessions court, but it's always good to have those ordinances in effect. My personal conviction on that, and I think a lot of your citizenry would want that as well, and we've used that before, but it may be, I don't know, maybe the law enforcement committee wants to maybe look at that, maybe share some thoughts that they may have on that, maybe the contracting the scope or broadening the scope of that one, because you see that more often. But overall, I've been looking at looking at it, it appears to me that a lot of the vestiges of the past are being removed, things that just simply don't apply anymore because they've been superseded by the Tennessee Code Annotated, and I would think that under the general law would be sufficient on those. So I didn't really want to keep those at all. Of course, some of your ordinances are modified properly to the urban services district, like the discharge of a firearm. I think that's appropriate, where you distinguish between the urban service district and that which is not. But other than that, and just reviewing my commentary on what I had seen, I agreed with the changes, Mayor. I didn't have a whole lot to add to it from the corrections that you made. I think I don't know if it was on my particular document or maybe it was just the formatting, but there were a few small minor typos, but those are all things that can be easily cured. So other than that, I don't have anything further to add to that other than discussion.
Looking through the document here, there was some things I put in the comments, and I'm looking at your paper as you were turning. It looked like it had the comments on there, especially I was looking at the miners and beer places. I had put in there a comment just to remove it completely, as it was superseded, in my opinion, looking at it by two subdivisions or subparts of 57-5-301. But what I've got on here where it's got scratch worked out, that worked in, I figured if it's going to be kept, we need to at least take out work in, because there is a provision in the Tennessee Code that specifically allows them to possess it if it's in the course of employment. So I guess my question on that is, do you think it'd be better just take it out completely, since we've got these two separate provisions of Tennessee Code that kind of cover these things, or do you think leave it in there and just take the work in, or is my interpretation as far as the work in incorrect?
In looking in that particular section, and from what I've seen, I know that in times past, deference to the Tennessee Code Annotated is probably would be better, in my opinion. I think you've got the language in there. Of course, it says in the course of employment. I think it's probably that's the same language that the Tennessee Code Annotated uses. Am I correct about that?
Yeah, I actually printed it out, and I'm gonna read it right here. It says, "It is unlawful for any person under 21 years of age to have in the person's possession beer for any purpose, and it is unlawful for any such minor to transport beer for any purpose except the same be in the course of employment."
Well, I think that's that language in the course of employment is going to probably would supersede anything that we would put in our municipal ordinance, in my opinion. I think just deferring to the Tennessee Code Annotated. Now, I know as a metropolitan government, we have broader authority to regulate than in some portions of that statute, but I don't think that's one of them that we can. I think to me, it's pretty clear that in the course of employment, with that the only exception. So.
So my preference would just be take the section out and just rely on the state statute, because to me you've got a state statute that covers, specifically prohibits loitering of minors loitering in a place where alcoholic beverages are sold.
And I think I agree with you on that. Of course, just in my own recollection, I can't recall anyone being cited or charged for that particular in my 26 plus years of practice. So I think the state statute is going to be the one that would apply and what most law enforcement officers would utilize.
Yeah, and a lot of these things, changes I recommended, I've never seen anybody charged under an ordinance. It's always been under state law. So, but then if it's all right with you, when we go forward as to law enforcement, I'm just going to recommend removing that section completely and relying on the state statute.
I concur with that recommendation.
And I think, no, there was one under the firearms. So that'd be chapter 6. On the discharge of firearms. Again, there was on what I printed out, the comment's not showing, but I do have it on here. And I think I had a question about removing the snowball. And let me get to my comment. I think pretty much my comment was, has anybody ever been charged for throwing a snowball? And I don't think so. I've never heard of it being done, and I don't think that's something law enforcement really gets into. So I just was recommending or looking at the possibility of taking snowball out. Yeah, I think I've got it right here. Yeah, my question is it actually enforced for snowballs? And I think I talked to the sheriff about it, and he was pretty much saying, no, they never really enforced it for snowballs.
I think if it got egregious enough, obviously, if someone were to use a snowball and threw it and it did damage to a person or property, I think you're looking at an assault or a vandalism charge. So again, that's another instance of that particular ordinance section. And looking at it, I'm trying to think of another reason for even holding on to that particular provision, because I think most of the Tennessee Code Annotated would certainly be sufficient for a criminal charge or a citation. So that's just, but taking the snowball out, certainly I would agree with that.
Well, given that, would you just recommend just removing that section completely as far as throwing missiles? Because looking at it, I think you're right. There's TCA sections, whether it's assault or damage to property or something like that, that I would think would supersede this.
Every one of the items in there speak to either offense against a person or offense against property. And I don't know the utility of having that particular section. I'm trying to think of a reason why having it. Because I've never seen any citation issued along those lines, and I don't know what if the sheriff could speak to that and say whether he had or hadn't citation. I would venture to guess that he had not. But I think the purpose of that is to deter the offenses against the person or property. And both of those are included in your Tennessee Code annotated already.
Okay. And I'm just gonna make a note here, just remove that section. And I think I had some other questions on chapter 7. This is the trespassing, malicious mischief, and interference with traffic. I think I had kind of the same thing, looking at trespassing as being superseded by TCA 3914-405. So again, this is another one of those things where there's a state statute to me is probably on point with this, and if they could charge anybody, it's going to be under the statute, not under this. But again, if my interpretation is is wrong on that, please don't hesitate to say so.
The one thing I have with regard to that particular section under paragraph 2, it should be unlawful and deemed to be a trespass for a peddler, canvasser, solicitor, transient merchant, or other person to fail to leave promptly the private premises of any person who requests or directs him to leave. I'm wondering, just as a thought process, if a person, a private landowner, if that would avail them any additional protection as opposed to the criminal trespass statute, under maybe a criminal summons or something of that nature, because I can actually envision a situation where that language may come necessary. I think it's something worth the discussion in the Law Enforcement Committee. I'm just thinking in terms of where typically if someone leaves a premises, they're not going to get charged with a criminal trespass. But there's almost a certain amount of deterrence that ordinance has for someone who doesn't promptly leave. I've seen scenarios where a person will come on another person's property and someone won't demand that they leave, and they want to linger around and have a discussion with them. Then law enforcement's called and diffuse the situation. No one gets charged. It's almost a deterrent effect that if you have that for a private landowner or a business, I think it adds a little more than what I don't necessarily think that it flies in the face of the criminal trespass statute. I think it adds a little bit more than what the criminal trespass statute would call for. So I think it's more one of those additional rights, but that's just my opinion on it. I certainly would like to hear more input on that from other people to see what they would have to say about it.
All right, and then on the next one would be malicious mischief. I think on that one I've got possibly superseded by 3914-103 and 3914-408, which are, I think, Well, I had some papers here that I was reading off of.
That
Yeah,
looks
those
like
didn't work.
conversion almost.
I'm sorry, can you repeat that?
It looks like conversion almost to, it could be vandalism. I'm gonna have to think about that one a little more carefully. I looked at that, but it looks a bit like vandalism and theft.
Yeah, that's what I got in my notes. I got 39, I guess 14,408 vandalism and 39,14,103 theft.
It's probably superseded by those statutes. I'm not seeing anything in there that to me, I mean, what's the penalty for it? $50 fine and a 11-month, 29-day in custody or incarceration. So I think it's both vandalism and theft would fall under that. But the only question I had was that it also looks like civil conversion,
Okay.
which is I'm wondering, does that add anything to or take anything away from what a citizen would want? It certainly, if it didn't rise to the level of a criminal case, that ordinance in place, if someone were cited that and found guilty of that, no matter what the penalty, I think it makes it I think it enhances any type of civil conversion lawsuit, is my thinking on it. That was my only, it may have a misnomer though. They call it malicious mischief.
So I just say right now, just leave that one for more research and discussion.
I'm gonna put a question mark for discussion on that one with the group. It may never come up, but it's certainly interesting.
Then there was one for the next chapter. I've got 11,803. And it's really just a question I've got on. It's talking about posted notices. It says no person shall fasten in any way any show card, poster, or other advertised device or sign upon any public or private property unless legally authorized to do so. And I just guess what would be the proof of the authorization? I could see it on public property to an extent. They could get something from me or the county commission authorizing them to do it, but on private property, I guess it'd just be a letter or something from somebody.
Landowner, of course, they could be verbal or oral. It's just like with someone wants to put a sign upon an advertising sign. Typically, they'll find a highway with a major thoroughfare, and they'll put up their, and they'll have a lease agreement. Obviously, a lease would be authorization, but I don't know. Maybe that's something that garage sales, or it may have. I'll tell you what, it may have. One of the reasons for it may have to do realtor signs. When a lot of time your realtors don't ask for permission, not picking on them or anything, but I've experienced that myself in a couple of municipalities that I've represented, and as a business owner myself, I've had realtors stick a sign on my property or in at a four-way advertising an auction or something for sale. And they've never had the permission from the local government to do it or the landowner from doing it. Albeit it's probably not it's not a criminal act. I can't think of what possibly that would be. So that may be the reason that's there. So is any of our realtor commissioners on the Law Enforcement Committee, they may want to.
There may be one or two.
I think they may want to have some, of course, then you get into First Amendment issues as well.
You know, and that was kind of thing I was thinking about as you're going through it, thinking, well, if we're gonna, for a private property owner, it's not an issue, but when you get to the public, we're saying you can put up a campaign sign, but you can't put up a sign for a commercial business, well, then I'm discriminating against types of speech, and that, to me, creates all kinds of problems.
I think you hit the nail on the head. So I think that's something we need to kind of look at, but I would certainly, I don't know what the will of the committee is or the commission on that point, but I know in certain municipalities that they regulate signage, but it goes by standard. There's a uniformity across the board, and I don't know if that's something that they want to consider, maybe looking at that issue. I know there may not be a big ticket item or big problem right now, but you take a place like Pigeon Forge or Gatlinburg, I bet they've got some type of sign ordinances up, and or even communities like an HOA, they're not going to allow you to put up certain things. I know we're a local governmental entity, but whatever we do, it would need to be uniform across the board and not harm First Amendment rights.
I think the only thing we have right now is in the zoning, and it kind of goes towards, I don't know that it covers placement of sign. I know it covers size of signs that can be put in certain places, but I don't think it has anything to do with the content of the sign. And I have received a couple of comments and questions about the people putting advertising signs and whatnot in the new streetscape out here. And so far I've explained to people saying, well, if I tell this business they can't go out there, which right now I have no legal authority to do so, then how can I tell Bob he can't put his campaign sign out here? And then that's a discrimination based on the content of your speech, and you get into all kinds of problems. So that might be something the committee wants to look. I think it's a discussion that should be had just to get it out there. If more people out there got questions on it and don't know it's being addressed, but just to make everybody aware when you start going down that road, as far as a public local government, you start getting into all kinds of problems people don't realize when you try to start regulating speech. And I think some people don't realize that a sign is just, the content on the sign is speech. Next thing I got in this one is I just added in a section of exceptions. I actually got this from Wilson County, or excuse me, City of Lebanon's code. As far as exceptions on the curfew for minors, I know our current code didn't really cover that, but I thought that would be good to include it in here because it does cover a lot of scenarios that I think are out there, were not addressed in our current code.
I don't know exactly what the practice is. I know with curfew, it's obviously, it's an unruly charge that would be brought in juvenile court. And most of these are defenses to that. that are allowable by most courts. So,
But do you think it would be good if we're going to adopt this to put language in there saying, of course, that's not something I ever practiced in, so I can't get into what all the defenses are to that. Would it be good to put a language in here saying that, I don't want to say that these are defensive, but some kind of language saying that this is a non-exclusive list, because there might be other ones out there that are not included, and I don't want it to look like we're limiting those.
kind of an included but not limited to.
Yeah, some language like that, or do you think it's better just to leave a section like this out?
I don't know. That's the Bill of Rights argument. Do we put it in or do we leave it out? And I thank God that they put it in.
Well, I like having it in there. To me, I know that in some cases I've been on, I think having that actually out in writing helped the law enforcement officer and also helped me address some issues that they were talking about. So I think it helps. To me, to an extent, it would help, but I don't want to possibly harm anybody that may be charged with breaking curfew and look like we're trying to limit any or possibly limit that, or put in anybody's mind that's going to enforce that this is an exclusive list and anything beyond that doesn't exist.
I think if we put an item 10 that basically said something to that effect, that this is a non-exclusive list. And just obviously those things are
Should put a non-exclusive list and other, I guess call them exceptions. I'd rather call them exceptions than maybe defenses.
yes
Exist in, what would you say, statutory or common law?
statutory common law. Take it under the wearing mask, the public.
Yeah, I only made a couple of changes in this one, or suggested a couple of changes, and one of them, I think I deleted it. I added as a section 4 that was on here for public health emergencies, given the world we're living in. And that just because we haven't had a pandemic like this in 100 years, don't mean we won't have another one anytime soon. I also kind of think by the time you have a public health emergency, I don't see any law enforcement officer, if you are having one of those, enforcing that against anybody having it. But again, that might be me being a little bit overcautious putting that in there, but I just wanted to include it. Again, if it's not necessary, I'm not really tied to it. I just put it in there because, like I said, the world we're living in right now. And then also the requirement, I guess, was it put in there? Yeah, basically requiring a special permit issued by a town clerk to wear a traditional holiday costume. To me, that was, I don't know that the sheriff's department wants to be running around doing that. And I also talked to, since we no longer have a town clerk, it'd be the county clerk, and that's not something she wants to be involved in.
I agree with deleting that section completely.
I think that's really the only major pieces I saw, or the ones I had questions about or wanted to get further input on.
I don't have anything further. I think that once we have an opportunity to have the other members weigh in, let them look at it. I think this is something that would be amended very readily.
Okay. And I'll go back and reformat it. What we had done on the personnel policy is took the comments and actually made them as footnotes. That way, when you print it out, the type's not so small. So we'll just go back and reformat like that with the red line changes and those footnotes. Now, the footnotes that are currently in there, where it references other municipal code or state statutes or anything like that, I didn't make any changes to those. I was just looking at these sections as it went, because some of it refers to titles, which there's really no changes in the titles. So I didn't see change anything there. And then this reference down here at Tennessee Code Annotated 33-8-203 saying the arrest for public intoxication, that cities may not pass separate legislation. I don't know that this has been changed since town of Hartsville doesn't exist, and I don't know that that statute's been changed either. And I'd have to admit, I didn't look at it, and I don't think it's been changed, but I didn't research it to see if it had been. I think that's pretty much all we've got for right now. That's pretty much the entirety. I believe that is the entirety of Title VII. And like I said, I spoke to the sheriff and Chief Cochran, and they didn't see any issues with the changes.
I think the changes are in order, and so I would recommend those changes to the full committee, and we'll, I guess we'll have further discussions at the meeting amongst.
Yes, sir. We were to kind of come up with a suggested changes and bring it back to the full committee. So I'll just put together the changes we discussed here today and amend that, and then send that out to the full committee and get a date scheduled for those discussions.
Okay. Very well.
Well, thank you very much for coming, Mr. Beller. I'm going to run to the back and turn this equipment off.
Yes, sir. Thank you.